Hello, and welcome everybody. Thank you so much for being with us on another webinar. As you can see today, we're going to be talking about military divorce. We're going to give you an introduction to military divorce here in New Jersey and talk about how federal laws and branch policies affect the New Jersey divorce process. Our disclaimer as always, this presentation contains general information and does not constitute legal advice. Be sure to direct your specific questions about your own case to an attorney. Weinberger Law Group is not affiliated with the United States military. So what are we going to talk about today? Well, today we're going to give you an introduction to military divorce in New Jersey, talk about common procedural issues out there, payment of child or spousal support, issues with child custody and parenting time, issues in equitable distribution of property or debt, and we're going to talk about military benefits in the divorce process. We're also going to give you some information if you have questions or need additional help. So let's talk about first some common procedural issues with regard to military divorce. Some residency requirements. In a civilian divorce case here in New Jersey, one or both spouses must have lived in the state for at least 1 year immediately before the filing for divorce. The minimum time period is waived if the grounds for divorce allege adultery. In the military, service members and spouses have less restrictive requirements, and they can file in the spouse's state of residence, in the state where the service member is stationed, or in the state where the service member claims legal residence. Now, where can a service member claim legal residence? Well, either the service member's, quote, home of record, which will be the state of enlistment indicated on their leave and earnings statement, or the state in which the service member intends to reside after leaving service. Things to consider if you have your choice of states where you can file for divorce. The case will remain in the original state unless there is an agreement or a successful motion before a judge to transfer your case to another state. Think about if there are any issues likely to be ongoing after one or both of you move to another state. For example, parenting time orders or payment of child support. Now, children must generally reside in a state for at least 6 months before the state court can issue custody and or visitation or parenting time orders. The court does not have jurisdiction over the child before that 6 months. Now, serving divorce papers. To start the divorce, one spouse, who will become the plaintiff, must file the complaint for divorce with the supporting documents required with the family court and then serve these papers on the other spouse, who then becomes the defendant, along with the summons and the proof that the defendant has been served properly. There are several ways to accomplish service. Now, there can be service by mail. There can be personal service, which is preferred and must be attempted first. And then there is substituted service on a special agent or service by publication in the newspaper. Now, if you know that the defendant will accept the paperwork, mail is usually the simplest method, regardless of civilian or military status. You would send the complaint and the documents by regular and certified mail, return receipt requested, to the defendant or to their attorney if they have one. The defendant then returns and signs a signed notarized acknowledgement of service form back to you to file with the court. Now, that form says, yes, I got the papers, I understand I have the right to be personally served, but I waive that right, and let's go forward with the divorce. Now, personal service with regard to the military. Many U.S. military bases are closed to civilians, and on some, federal law governs rather than state law. If your spouse is in the United States but off post, the sheriff's office or a process server can serve the papers personally according to the state law. There will be a fee based on mileage and required number of trips. For service on post, contact the commanding officer or the provost marshal and follow their instructions on how to properly serve your spouse. Now, if your spouse is overseas, service can be really especially challenging. If you know that your spouse may soon be deployed overseas, try to address any urgent situation before they're deployed. Hague Convention countries generally permit service by mail to a, quote, central authority in the host country. In non-Hague countries, the procedure will depend on the agreement between the host country, where your spouse is, and the U.S. military. Protection from default. This is found in the Service Members Civil Relief Act, or the SCRA. Now, this law is a federal law that extends various protections to members of the service who are on active duty. And one of those protections is protection from default being entered against them. Ordinarily, if a defendant doesn't respond to a New Jersey divorce complaint within 35 days, that person can be found to be in default, and the plaintiff can ask the court for a judgment of divorce by default. But under the SCRA, a judge cannot enter a default against a service member unless the service member waives the protections of the law, or the court first appoints an attorney for that service member. If the attorney cannot contact the service member, or the court finds that current military service or service within the past 90 days is affecting that service member's ability to appear and present a defense, the court will stay the proceedings for at least 90 days, meaning the court will table them, will not entertain, and will wait for at least 90 days for there to be some sort of movement or response from the military member. Now, additional stays or stay after the notice require an application, including the following. There has to be a statement from the service member indicating how their military duties affect their ability to appear, and a date that the service member will be available, and a statement from their commanding officer indicating that military duty prevents the appearance and that leave is not currently authorized. Now, opposing a stay of the proceedings, the service member is required to act in good faith and exercise due diligence in attempting to arrange an appearance in court. If the non-military spouse believes that the service member is exaggerating the difficulty involved in making an appearance in court, or that the service member's personal appearance really isn't necessary, it is possible to oppose the stay of the divorce. So let's talk about some child or spousal support payments and how New Jersey law and military policies affect payments. So New Jersey family law on payment of child or spousal support. The payment of both child support and spousal support in New Jersey is governed by state statute, and you could see the statute citation there. New Jersey court rules 5:6a and Appendix 9 impose additional specific guidelines for payment of child support. If you do not have a court order or a legal agreement addressing payment of support, branch regulations or guidelines govern temporary support payments. Temporary family support and the U.S. Navy policy. Support is payable at different percentages of gross pay depending on whether there is a spouse only, 1/3, a child only, 1/6, or a spouse and one child, 1/2, and etc. For details on this formula and policy, see the Navy Personnel Manual 1754-030. Family support and the Marine Corps policy. Minimum support payments are based on the number of dependents or, if higher, a percentage of the housing allowance. For details about this, see Chapter 15 of the Marine Corps Legal Administration Manual. Now, for the Army regulations, minimum support payments vary depending on living arrangements and military or non-military status of the spouse. For further details on the Army regulations, see Regulation 608-99. And the Coast Guard policy. Minimum support is calculated as a percentage of base pay according to the number of dependents, also factoring in differences in housing allowances with or without dependents. For details about this policy, see the Coast Guard Discipline and Conduct Manual, Section 2E3, Support Requirements in the absence of a court order. And the Air Force policy. The Air Force directive defers to state court for calculations. Minimum support must be, quote, adequate. And for details about the U.S. Air Force policy, see Air Force Instruction 36-2906. New Jersey family law and military income available for support. Military income available for New Jersey child support and or spousal support includes both basic and special pay, as well as any benefits provided in lieu of pay, such as food and housing. The service members LES will include amounts for basic pay and any special amounts such as jump, dive, or flight pay. Calculating available gross income requires review of the LES and assessment of an appropriate value for any benefits received in lieu of pay. So how do we enforce support payments? A court can sometimes proceed with an order for temporary support, even if a service member is attempting to stay the proceedings. A hearing may be held via telephone conference. Now, once you have an order for payment of support from the family court or from the New Jersey Office of Child Support Services, you can request wage garnishment through the Department of Finance and Accounting Services. What are some common issues in military divorce, such as custody and parenting time? Well, child custody and parenting time in New Jersey family court states that state law governs parenting orders and agreements in military divorce. That's by statute. You see the citation there. The overriding concern is always what is in the best interest of the children. Now, New Jersey favors frequent and continuing contact with both parents, and both parents are encouraged to make their own custody and parenting time agreements. Parents can agree on any combination of physical or legal custody that addresses the child's best interests. Now, what about jurisdiction over the children? Now, regardless of where a divorce is initiated, the state the children have resided in for the past 6 months will have initial jurisdiction over them. We talked a little bit about that earlier. Even if a child is a U.S. citizen, jurisdiction may belong to a foreign country. So establishing initial jurisdiction is really critical, as authority over changes to parenting time or custody generally stays with the original court unless there is some sort of mutual agreement of the parents or an order from the court to transfer jurisdiction. New Jersey law states that if a child is living out of state on a temporary modification order, New Jersey will retain home state jurisdiction. Now, parenting during service-related absences, what happens there? Well, deployments can be unpredictable and require difficult adjustments. Active duty can certainly increase the risk of physical or psychological injuries. A New Jersey law enacted in 2013 addresses the need for really special flexibility in child custody arrangements and parenting time plans when one or both parents are in the service, and you can read more about that law at NJSA 9:2-12.1. So what are some protections for service members in New Jersey regarding custody and parenting time matters? So timing of orders. New Jersey law prohibits permanent custody decisions while a parent is absent for 30 days or more due to a deployment or treatment for a service-related health condition. Courts must wait at least 90 days after the parent's return before entering permanent child custody orders or making permanent changes to an already existing custody or parenting time order. What about parents' responsibilities? Well, the departing parent must notify the other parent of the anticipated absence dates and location no later than the day before departure or the 10th day following receipt of official notice, whichever is earlier. To the extent reasonable or feasible, the non-departing parent must facilitate electronic or telephonic communication between the child and the absent parent while they're gone. Changes are temporary. Temporary modifications must allow the departing parent to exercise parenting time during leave and must expire automatically when the parent returns home. Original orders will resume after the parent returns home unless the other parent can demonstrate that this is not in the child's best interest. Enhanced flexibility. Now, a parent cannot base a request for a change in custody or parenting time on the other parent's absence due to military service or treatment for a service-related health condition. Children do not automatically stay with the non-departing parent. The court will consider other options. Some flexible options for temporary changes in parenting orders during deployment or service-related treatment are: the child may stay with the other parent, the child may accompany the deploying parent, or the absent parent may delegate parenting to a family member with a close personal relationship to the child, perhaps a grandparent. Some factors that courts consider in determining appropriate modifications to custody or parenting time orders. Temporary modifications will be based always on the best interests of the child after considering all relevant circumstances, including which parent has been the primary caretaker, what conditions the child would face in the deploying countries, such as safety, childcare facilities, health, enrichment opportunities, what kind of arrangement the other parent or an alternative caregiver can provide for the child. Now, New Jersey custody and parenting time hearings. There are expedited dates and presentation of evidence in military situations. A parent facing an imminent deployment or treatment-related absence that would prevent appearance or full participation in a custody or parenting time hearing or a parenting evaluation can request an expedited date before deployment without waiving his or her rights to request a stay. If a parent is already out of the state, courts can take evidence and testimony by electronic means, such as telephone or internet conference. What about distribution of property in a military divorce? In New Jersey, all property and debt acquired by either spouse during marriage, except generally inheritances and gifts, is marital property. New Jersey is an equitable distribution state, meaning that upon divorce, all marital property is divided fairly, but not necessarily 50-50. And courts consider a long list of factors when determining how to divide property or debt, and that's found in statute or state law NJSA 2A:34-23.1. Distribution of retirement assets. Now, distribution of retirement assets such as IRAs or traditional pensions is complicated, and attorney assistance is really important to make sure you don't sacrifice any of your rights. Now, retirement assets earned during the marriage are marital property, but special rules apply to distribution of military pensions. If a service member has both a pension and another form of retirement asset, each will require a different method of valuation and evaluation and a different type of court order for division. So let's look at the so-called 10-10 rule with regard to military pensions. States have authority to divide military pensions in divorce, really regardless of the length of the marriage. If a couple has been married for at least 10 years and the service member has completed at least 10 years of creditable service during the marriage, the DFAS will pay a former spouse's share of a pension directly to the former spouse. This is sometimes called the 10-10 rule, 10 years of service. So what are some military benefits in divorce that are addressed in the courts? Prior to the final judgment of divorce, a civilian spouse who is separated from a service member will generally retain all military spousal privileges, including medical benefits under TRICARE. After final judgment of divorce, the spouse will be entitled to purchase transitional medical benefits under the CHCBP, which is similar to our COBRA, providing coverage for up to 36 months of the non-service member spouse. Now, the service member's dependent children remain eligible after divorce for TRICARE. Continuing military benefits. This is the so-called 20-20-20 rule. A former spouse retains full benefits, including commissary and exchange benefits, if all of the following conditions exist. The former spouse was married to the service member for at least 20 years. The former spouse is not remarried, and the service member has had at least 20 years of credible service during the marriage. Medical benefits will be suspended during any period of employer-sponsored coverage. So the ex-spouse gets a job and there's employer-sponsored coverage, the military medical benefits will be suspended. So what about the 20-20-15 rule? Well, a former spouse retains 1 year of medical coverage under TRICARE with no additional benefits if the following conditions exist. The former spouse was married to the service member for at least 20 years. The former spouse has not remarried. The service member has had at least 20 years of credible service, and at least 15, but less than 20 of those years of creditable service occurred during the marriage. What about the election to pay the former spouse? Now, a service member may elect to provide a monthly annuity under a survivor benefit plan to a former spouse. But, and this is a big but, electing to do so precludes an award to a current spouse. To be enforceable, the election must be in writing, signed, incorporated into the divorce decree, and transmitted to the secretary of the appropriate branch of service within 1 year of the entry of the decree. Well, for more information about New Jersey divorce, visit weinbergerlawgroup.com. We have a bunch of information on our website, including some blogs for you to take a look at. Or you can look at our various books that we have out on divorce, child custody, child support, and more. You could see some of our titles there. Now, do you have other questions about military divorce in New Jersey that maybe we didn't cover here or that are specific to your case? Well, give us a call. You see our toll-free number there, 888-888-0919. Shoot us an email at info@weinbergerlawgroup.com, or we do have an Ask a Question section on our website at WLG.com. As always, if you want to come in and talk to one of our qualified family law attorneys about your military divorce or any other question that you might have, please feel free to give us a call. Schedule your confidential and free legal consultation today. We look forward to welcoming you into our office and meeting you. Well, we hope you learned something today and enjoyed our webinar. Again, if you have any questions, give us a call, shoot us an email. And as always, we look forward to welcoming you back next time on another edition of Weinberger Law Group webinars. Thank you so much.